morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair.
Are you ready?
Yes, we're ready, Chair, to proceed with the events of the day. But to begin with, there are present at least 10 legal representatives, some representing the same party, others representing others. But as discussed in Chambers, Chair, may they place themselves on record?
Yes, please. They can do so. You may do so from where you are seated if your mic works. If your mic doesn't work, you might have to go to the podium then. But they will sanitize the podium before you use it.
Thank you, Mr. Chairperson.
Yes.
I beg leave to remove my mask.
Yes, okay.
Thanks. Chairperson, my name is Rapulane Khawsit Michael Khorayadir from Khorayadir Mutau Incorporated. I represent Mr. Arthur Fraser, Advocate Bongani Pongo, Mr. Chablani Matuma, Mr. Graham Engel, Mr. Prince Makwatana, Ms. Marty Wallace, Ms. Molini Mnana, and Ms. Roxanne Human, who are likely to be implicated today. One has to add, Chairperson, that our council, or before getting to our council, I'll be appearing with two of my colleagues, Chris Mudau and Tsepo Homum. They'll be joining us a bit later.
Yes.
Our council is Advocate Moses Kakani and Advocate Clifford Mutsepe, who are unfortunately not able to join us today. With the permission, Chairperson, I would like to address you on a few other issues.
Let's finish the introductions first, and then when everybody has introduced themselves and placed themselves on record, then you can address me on the other issues.
Thank you.
Okay, all right.
Chairperson?
Yes.
My name is Advocate Vumbi Rendani. Chairperson, I'm on instruction from PG Matseka Attorneys. I will be appearing here with my instructing attorney, Ms. Palesa Matseka.
I'm not sure whether with the mask on the transcribers would have heard everything you say. I want to see if there's an indication that, yeah, they say they did hear. Okay, all right. Thank you. Okay, thank you.
Chairperson, I don't know for the purpose of record if I should say my client in terms of who I'm representing.
I'm sorry, just raise your voice. I am struggling to hear you.
Chairperson, I was saying for the purpose of record, I don't know if it's permissible to say my client who I'm representing.
Well, you know best what it is that might militate against you saying who you represent. You might wish to, I don't know if you might have had a discussion with Mr. Pretorius on the issue.
Chair, certain persons who will testify or may be implicated have been given pseudonyms to protect identities for various reasons related to state security.
Yeah.
If the person being represented is such a person, you may use a pseudonym.
Yes, because the intelligence community has got its own special features, and there is legislation to that certain people, their identities need to be protected. So I guess that if your client is one such person, then there will have to be some alphabet given to him. Maybe Mr. Pretorius may assist because he knows up to what alphabet he has used so far.
No, in the documentation, each such person whose identity requires protection has been given a pseudonym. And so legal representatives would know.
Yeah, oh, okay.
The legal representatives then are invited, certainly by us, Chair, it's in your hands, however, to use that pseudonym.
Okay.
Chairperson, thank you for that. We had a serious issue with the pseudonym that was used for our client. That is why which I started by asking permission in terms of if I should, if it would be necessary for me to say the name, because the pseudonym that is used is closely, if not same, in terms of pronunciation to our client.
I think I would suggest that you get an opportunity to discuss with Mr. Pretorius, to discuss that issue with Mr. Pretorius to see if you can reach agreement. And then once there's been that discussion, then I can be told what the position is.
I think I will agree with that.
Is that all right?
Thank you.
So for now, I'm not going to know who you represent, but I know you represent somebody.
Thank you, Chairperson.
Okay, all right.
Good morning, Chair. My name is...
Good morning.
I will be in this proceeding, or from Sikinya Tennis, I will be in this proceedings representing the former minister, Mr. David Machovu.
Thank you. Okay, all right. Now, if everybody, if all the legal representatives, or there's still another one. Oh, I'm sorry, okay.
Good morning, Chair. Good morning, everyone.
Good morning.
I'm Neville Kaula from Kaula Incorporated on behalf of Ms. Mokwena. Thank you, Chair.
Thank you, thank you. Just sanitize before passing it on to somebody.
Good morning, Chairperson.
Good morning.
Yes, Chair. My name is Puseletso Saudi. I'm here on behalf of Abraham Skivitz, attorneys. Our client's name has been used as Apricot, the pseudonym, but they are not a member of the intelligence community or anything. But
Okay, I think there is something wrong either with your voice or with,
Can
with
you hear
the
me now?
mic.
Oh, okay.
I think
Yes,
it's
yes.
your voice or how you are holding the mic.
Oh, okay.
Just start afresh.
Oh, yes. Morning, Commissioner.
Good morning.
My name is Puseletso Saudi on behalf of Abraham Skivitz, attorneys. Our client's name has been used as a pseudonym, Apricot, in the documents. And so we will stick to that for now. Thank you.
Okay.
Good morning. My name is Madi Mecha.
Good morning.
Am I audible, Deputy Chief Justice?
Just start afresh, please.
My name is Madi Mecha Lamola
Yes,
from Lamola Tennis in Pretoria.
yes, I can hear you.
Yes. We are here on behalf of Dr. Siyabonga Cwele. We are already on record in this matter.
Okay,
Thank you
okay.
very much.
Thank you very much.
Morning, Deputy Chief Justice.
Good morning.
My name is Advocate Begin Debele from the Pretoria Bar, representing Dr. Mufamadi and the State Security Agency. I'm with my senior colleague, Marumo Morane, who is joining the commission virtually. Thank you.
Okay, okay, thank you.
Thank you.
Morning, Chair.
Where is...
Can you hear?
that is Mr. Mwerane's voice, but I can't see him.
He's
yes,
present remotely, Chair.
Yes, yes, Mr. Mwerane. Good morning.
Good morning, Chair. Good morning, Chair.
Good morning.
As my colleague has said, Mr. Ndebele, I represent Mr. Mufamadi, instructed by the state attorney in these proceedings.
Okay, no, thank you, Mr. Murane, thank you.
Thank you, Chair.
Yes, was this the last one of the legal representatives to introduce themselves and place themselves on record? It looks like. Now, I think one of them wanted to raise some preliminary issues. I'm giving you a chance to indicate now what those are before what they are. I'm not saying that we must discuss them. I just want to know what they are, and then we will. I will indicate where in the sequence of events they may need to be dealt with.
Thanks, Chairperson. The issues that we want to raise, one has to do with our appearance.
Chair, may I ask
Yeah.
if he's sufficiently distanced, my learned friend is sufficiently distanced from everybody else, that he be permitted to remove his mask so that we can hear?
Yes, so we can hear clearly,
I'd
yes.
forgotten the permission, Chair.
Yes,
My apologies.
yes.
The one issue that we want to raise, Chairperson, has to do with our appearance on behalf of all
The number of clients you are appearing for.
Yes, there are issues with regards to the appearance.
Yeah.
Two, would also want to bring an application for the proceedings to be held in camera. Three, would like to request, or rather to address the Chairperson on a request or a request that we have made for documentation. And finally, on the inability of our clients to elect whether...
On the what of your clients?
Inability
Oh, okay.
of our clients to elect whether they would want to give evidence, call any witnesses, or cross-examine any of the witnesses against them.
Well, one, as far as you wish to bring any application, you would have read the rules, you would know what to do to comply with them.
Well, Chairperson, the rules provide for the application to be a substantial kind of an application, but they do not exclude a possibility of an application being made from the bar as we intend doing.
Well, if it's an application for evidence to be heard in camera, I think it would need to be a substantive application.
Okay, well, Chairperson, in
It's
that
quite
case...
a serious matter. It's not one of those just procedural and simple things.
Well, we are more than willing to at least leave that part, that application, but address you on other issues.
Yes. Okay, well, I'm not sure about the other issue. The other issues you said is the inability of your clients to elect, to exercise one or more of their rights in terms of the rules. Can you elaborate on that? I'm not sure what that is.
This is related to their right to legal representation. As things are, Chairperson, my instructions in respect of all my clients except Mr. Fraser, end today. But would like perhaps the assistance of the Commission going forward.
You don't mean you are asking the Commission to provide financial assistance for him
No,
to
not at
get
all.
lawyers?
Not at all.
So,
well, but if the Commission is willing to pay.
well, what kind of assistance do you ask for the Commission?
Okay. Well, Chairperson, in keeping with Rule 335 of the Commission's rules, the notice advised our clients that they're entitled to be assisted with by a legal representative of their choice. Consequently, apart from Mr. Fraser, who was already represented, all other clients, upon receipt of their Rule 335 notices or Rule 33 notices, apply to the State Security Agency for confirmation that the agency would be responsible for their fees. The application to the agency is informed by the fact that the activities forming the basis of the evidence implicating them are official activities of the agency, or that rather relate to official activities of the agency. And in the, well, as members, and in the case of Advocate Bongo, in his capacity then as the Minister of State Security. Such a request we submit, Chairperson, to the agency is not unprecedented. As we are aware,
I can understand the request to the agency, but I'm trying to understand where the commission comes in. So what relief are you asking from the commission in regard to?
well, the relief that we seek from the commission is that to the extent that the agency has to date failed to respond to our clients' applications, we request then that the commission, at the very least, I suppose, cajole...
Interferes.
No, not interfere.
You want the commission?
At the very least, to cajole the agency to respond to the application. They don't have to say yay as per the direction of the agency, of the commission. But there must be a response. There has been no response whatsoever. And it affects our clients' right to representation.
I thought attorneys have quite some weapon that they normally do when somebody is not responding. They threaten litigation.
Well, but
and in a number of times then there would be a response, either favorable or not favorable.
Chairperson, there is no point in making threats that you can't carry out.
Surely, definitely.
My clients do not have the money
Yes.
to bring in an urgent application to compel the agency to at the very least, respond.
Yes.
It is a submission that the chairperson is better placed, at the very least, to request the agency to respond to our application.
I would have liked to assist, but I don't think that I've got any power to get involved in those matters.
But we assume that...
And of course, you are not pointing to anything in any instrument that gives me that power. Of course, it would be good that everyone who needs legal assistance should get legal assistance in order to be here. But we can't get involved in under what circumstances it should be granted or should not be granted. We can't. That falls outside our jurisdiction. You understand that?
We can't take the matter any further,
Yes.
Chairperson.
Okay, all right. But
and I suppose...
we hope the agency will at least respond one way or another.
Given what you know about the agency, they are not going to respond.
Yes. Okay. Thank you very much.
Chair, with your permission, I'm
Yes.
not sure whether while Mr. Khweradira was on these points, also point you out to the Commission that we also have almost the similar points to raise with the Commission. I cannot take
But
it
at least
further.
you know exactly what I've said to your
That's
colleague.
correct. I'm just noting for the record
Yes.
that we have the
Okay.
similar predicament.
Okay, all right, thank you. Okay, all right. Mr. Pretorius, I now give you a chance you want to do your opening or to explain certain issues?
May I just, for the assistance of my learned colleagues, just enumerate the 4 applications. The first, and I'll deal with them in reverse order, the first in relation to legal representation, what may be termed an application for cajolement. You've made your position clear there, Chair. The second is the availability and the time when a person can appear. That can be part of a substantive application. It is not an urgent application to be made now. and you will no doubt deal with such applications as you've dealt with others when they come. The third is an application for documentation. That too can be properly motivated and set out and properly responded to. Much of the information we've received in correspondence deals with documents which have not been declassified, and that would take a process if the production of the documentation is warranted. And the application to hear evidence in camera, Chair, must be brought properly motivated on behalf of specific people. I can just give you the assurance, Chair, that the evidence to be given, at least by the first two witnesses this week, does not go further than what has been officially declassified by the Director General in consultation with the President's office and what is already in the public domain. May I proceed then?
Yes, yes.
Chair, you have before you a printed copy of the opening address. It is necessary with respect to place certain matters on record to place the evidence in its proper context. It's a document in a red plastic folder. Chair, the evidence to be given this week, at least orally, deals with evidence in regard to the conduct of the State Security Agency. And that evidence is given in the context of the evidence that the Commission has heard in relation to law enforcement agencies as a whole. The evidence given to date has focused principally on the prosecutorial arm of the state, in particular the National Prosecuting Authority, and the policing arm of the state. We've dealt with the South African Police Service, the Directorate for Priority Crime Investigations, Crime Intelligence, and the Independent Police Investigative Directorate. So it's in that context that the evidence of this week will be given, where we will focus on the intelligence arm of the state. Intelligence functions, Chair, are shared in this country under our Constitution by three main law enforcement agencies. The first is the Intelligence Division of SAPS, South African Police Service, that's Crime Intelligence. The second is the Intelligence Division of the Defence Force, and the third is the State Security Agency. You've heard evidence concerning crime intelligence. We will deal this week with the State Security Agency. What we will deal with, Chair, are the features of the state security framework which deal with vulnerabilities in the regulatory framework and which make the intelligence services particularly or especially susceptible to appropriation of capacity resources and financial resources for improper political and personal gain. What the evidence will deal with is the appropriation, and I use that word deliberately as not to foreshadow any findings you may make on the meaning of the word capture in the context of the evidence as a whole, but the appropriation of state resources in contravention of the constitutional framework for improper political and personal gain. Of course, what makes matters difficult is that the sensitive and secret nature of intelligence operations, and in our evidence we will respect legitimate secrecy requirements, and I stress legitimate secrecy requirements of the intelligence arm of the executive. It carries a heightened risk because it's in secret and because it's largely unaccountable. There's a heightened risk of corruption as operational funds and operational activities are not subject to the same level of scrutiny as other public budgets. The evidence will also deal with oversight bodies. The Inspector General of Intelligence will testify, The Joint Standing Committee on Intelligence, a parliamentary committee, will be dealt with in evidence, and matters related to the Auditor General of South Africa will be dealt with in evidence. We will also deal with the role of law enforcement agencies in relation to the alleged criminal activities of the State Security Agency. For example, you will hear, Chair, that much of the evidence of alleged criminality to be led this week was actually handed over to the Hawks as early as 2019, and more recently handed over to the NPA. We will also address certain other questions as to, in relation to the law enforcement agencies and in relation to the State Security Agency itself, had they been operating properly under the proper supervision of the Parliamentary Committee, the Joint Standing Committee on Intelligence, and the law enforcement agencies themselves, whether much of the work that this Commission is doing would have been necessary had the law enforcement agencies played their part, and you've heard much evidence about that, and we will deal with that again in relation to the State Security Agency. Chair, the approach that this Commission has taken consistently throughout is to ask the question, firstly, what happened? And that's part of the public nature of this inquiry. This inquiry must investigate, and the public is entitled to know precisely what happened. And that is the basis upon which the evidence this week will be led. But perhaps just as important, the Commission has focused on why this could happen. How could it happen that these acts of corruption, alleged state capture, fraud, could occur? And we will deal with that issue as well. And thirdly, in relation to steps that can be taken to put matters right, as it were, and to ensure that these things don't happen again. Now, in relation to those three questions, we must stress, Chair, that we've had a great deal of cooperation, both from the President's office and from the Office of the Director General of the SSA, and steps have been taken, and we will detail those steps. Whether the investigations have gone far enough, whether everything that should be dealt with has been dealt with is another question, and that is a matter that you will adjudicate at the end of the day. But what the SSA evidence will show, we know that in relation to law enforcement agencies, their inaction contributed to a great deal, in accordance with the evidence given, should you accept it, to what occurred. And that's one of the reasons why it was allowed to happen. But the evidence in relation to the State Security Agency goes further. Not only were the surveillance or intelligence functions which should have seen what was going on and taken steps to deal with it, and we know of evidence given previously that warnings were given to the former president. What not only did the SSA not do its work, that's what the evidence will be, but the SSA embarked upon projects itself in a manner which was completely in contravention of constitutional principles and constitutional dictates, to appropriate the capacity and the resources of the intelligence agency to favor political interests, factional political interests, and other beneficiaries who were not entitled to those benefits. And that is what you will hear about this week. So, firstly, Chair, state capture as an intelligence failure, in other words, the allegations that have been made before you that are alleged to constitute state capture To what extent, the question will be addressed, was this as a result of or contributed to by a failure of the intelligence arm? You've heard some evidence there already, Chair. Secondly, to what extent were factional interests that enabled corruption, allegations of state capture, protected by the State Security Agency, or capacitated by parts of the State Security Agency to protect them? Thirdly, to what extent was the SSA itself involved in corruption and the abuse of state resources? And so the evidence may show, and certainly there will be evidence to the effect that the State Security Agency itself, by appropriating state resources for illegitimate means, including corruption, may itself constitute the unconstitutional and unlawful appropriation of state resources, which may well, when you finally decide on the definition of state capture, constitute a direct project of state capture. And of course, Chair, the secrecy and unaccountability that places a veil of secrecy over the activities of the State Security Agency compound the problem unless there is strict legislative, financial, and supervisory control, particularly at the level of the Inspector General and the Parliamentary Committee, and questions will be asked about the effectiveness of these bodies at the relevant time. We will also deal, and today's evidence will deal with it to a certain extent, Chair, with the susceptibility of intelligence agencies to politicization. You will have heard evidence in relation to the white paper and how attempts were made in 1994 to transform the intelligence arms of the state so that they could comply with a very carefully thought out constitutional dispensation. And one of the primary objects of the new intelligence dispensation was that it should not be used for political purposes, let alone factional political purposes. Unfortunately, that was not carried out in the period under review, and the susceptibility of the intelligence agencies to politicization was in fact realized to a great degree over that period. If I may take the time, because I think it's important, Chair, to place this in its proper context as a matter of principle. In paragraph 43, we quote, in fact, a member of the Mufamadi panel, Professor Laurie Nathan, who says, "Intelligence agencies the world over have special powers that permit them to operate with a high level of secrecy and acquire confidential information through the use of intrusive measures. Politicians and intelligence officers can abuse these powers to infringe civil liberties, favor or prejudice political parties, and thereby subvert democracy. Because of their proximity to the country's rulers and their capacity to ferret out personal and party secrets, intelligence agencies have the means to wield undue influence within the state and political arena. In the light of these dangers, established and new democracies alike are confronted by the challenge of ensuring that their intelligence services respect the democratic system and are subject to democratic control. A failure to achieve this in countries freshly unshackled from authoritarianism can retard the consolidation of democracy. The obstacles to intelligence reform in these countries are formidable, however. They typically include an institutional culture steeped in the repression of dissent, the historical politicization of the intelligence agencies, a pervasive belief that democratic controls will reduce the agency's effectiveness, and a lack of expertise and confidence on the part of the new executive and parliament. Above all, reform is inhibited by the extreme secrecy and political sensitivity of the intelligence community. And those are precisely the challenges that have been faced and continue to be faced by our intelligence agencies. There was a second important shift, Chair, that took place when the constitutional dispensation was set in motion in 1994. And that was dealt with in the evidence of Sheikh and others last year, Chair, where the reform of our own intelligence services coincided with a paradigm shift in global thinking on security. So to put it starkly and simply, under the previous dispensation, prior to 1994, security was associated with the restriction of human rights, detention without trial, bannings, and the like. And that was the role and function of the security agencies in a Cold War context. The philosophy of intelligence agencies is to protect rights now, to expand rights, to ensure that citizens of a country are protected by the intelligence agencies rather than their rights removed. And it seems that that principle too has fallen by the wayside in the period under review. But that was the essence of the white paper. And so, Chair, the notion that the intelligence community should be there to restrict rights or to partake in political, factional struggles, as it were, or to go beyond their mandate, which is the protection of human security as a whole, rather than state security or parts of the state, for example, the former president, is fundamental to the evidence that will follow. Another issue arises, which is an issue of principle, and that is the evidence that will be given makes very clear that there should be a division between the powers and functions of the executive on the one hand and the operations of state security agencies on the other, to preserve the independence and the capacity of the intelligence agencies to do their job. That principle too has been eroded, and we will place before you the relevant legislation that deals with the role of the minister and the powers of the minister and the duties of the minister in terms of 2013 amendments to the legislation and the constitutional principle which is set out in paragraph 51 that it's only the political responsibility that rests and not the functional and operational responsibility that rests with the minister. However, that doesn't seem to be reflected in the current legislation, and it's something that you will be addressed on in due course. So the high-level review panel, chaired by Dr. Mufamadi, who will give evidence, itself made the observation that the legislated powers relevant to the operations of the state security agency under the control, in fact, of and supervision of the minister seemed to cut through the necessary boundary between political and administrative management, and that their delegation downwards may be at the whim of a particular minister. But you will hear detailed evidence about that in due course. And then the third weakness that has given rise to much of what you will hear about in evidence is the weakness in the regulatory framework and financial controls. And some evidence will be given there as to the frustrations that the Auditor General's Office has suffered in the past, and in due course steps taken to remedy that situation. And then, of course, secrecy, the use of classification and covert operations. Now, quite interestingly, Chair, the legislation empowers the Minister to make regulations, including regulations regarding classification, declassification, and the like. And that same Act says that the Minister need not publish these regulations. So one has the result that regulations which govern secrecy and the extent and ability of the Minister and the law enforcement agencies to keep matters secret is itself secret, which is completely contrary to our constitutional principles. So, for example, and there has been recent litigation where members of the public, Chapter 9 institutions or non-governmental organizations with the interest of promoting and preserving democracy, have an interest in whether a matter is classified or declassified, has an interest or have an interest in ensuring that the weapon of classification is not abused to conceal criminality, is not abused to conceal governmental inefficiency, or is not used to prevent embarrassment to any interested government party. But despite the fact that the citizen and citizen bodies have an interest in knowing those boundaries, that regulation is concealed from them. They are not entitled, as we understand the approach at present being conducted by the ministry. We're not entitled to see the law, which governs the very law that affects us. But we will deal with that, Chair, in due course. And I'm referring there particularly, Chair, to Chapter 25 of the regulations issued by the Minister in terms of Section 37(1) of the Intelligence Services Act. That material is in the files. We deal in more detail on page 12. It's not necessary for present purposes to go into too much detail here, but we deal in detail in the opening at least, and will in due course deal with the powers, statutory and otherwise, and in many instances abuse of those powers to keep documentation secret. So the white paper on intelligence in this regard says the following, Chair. The development of a more open intelligence community will go a long way towards demystifying and building trust in the national intelligence communities. Where legal limits of secrecy, including criteria and timeframes for classification, are clearly understood and accepted by society, the dangers of the intelligence system becoming self-serving are averted. But of course, Chair, the irony is that those legal limits dealing with classification at least are also secret. And then, Chair, we will deal in evidence with covert operations. The evidence in regard to what was actually done in the period under review is, to put it at its least, disturbing, Chair. And one of the difficulties, of course, that an intelligence agency will face is what is lawful and what is unlawful. But many of the projects, in fact, most of the projects about which you will hear were manifestly unlawful, and they will be dealt with, at least in summary and to a high-level degree, by Dr. Mufamadi. We will also deal with the high-level conditions which gave rise to the evidence of the unlawful projects about which we will hear. You've heard about the centralization of authority within the SSA in 2009 through the proclamation which was then issued and regularized by legislation only in 2013. And detail about that has been given in evidence and will be expanded upon by Dr. Mufamadi and others. But again, the centralization, which was done by proclamation in 2009, highlights one very important failure in oversight mechanisms. Parliament knew in 2009 that to change the structures and amend security legislation on the basis that was purported to be done in terms of the proclamation had to be done by Parliament, had to go through the consultation process in Parliament. When this happened, Parliament remained supine until 2013, when the Act was finally put into position, quote-unquote, regularizing what was done quite improperly and unconstitutionally by proclamation in 2009. So quite apart from the direct actors there was a complete failure on the part of Parliament in relation to that. The weakening of oversight, therefore, is fundamental factor in answering the second question that you addressed, Chair, and that is, how could this have happened? Why wasn't it picked up? Why wasn't it dealt with when it should have been dealt with? Chair, if I may just mention two things that will arise in evidence. In 2006, a principal agent network was established. It was terminated in 2011. Arising out of what were quite clearly unlawful activities, there were a number of investigations. Those were the PAN investigations. That investigation was initiated in 2009 and finished in 2012. However, the unlawful activities didn't end, and why that happened and at whose instance that happened will be dealt with in evidence. So that during the period 2012 to 2018, further activities took place about which you will hear in some detail, which were manifestly unlawful and undermining of our constitutional democracy. That period has been and is being investigated by the SSA internally itself. The problem is that that investigation doesn't have the powers, ironically, that a thorough and proper investigation should have, and you will hear of many projects which have yet to be fully investigated, projects of great concern, and that is Project Visa. So you have PAN on the one hand dealing with the principal agent network activities and investigation dealing with an earlier period, and Project Visa dealing with investigations of activities in the later period.
I think that VEZA is probably isiZulu and would be VEZA, Project VEZA.
VEZA.
Which
okay,
means something along the lines that you must show or open up something.
Yes, we've adopted the pronunciation that we were told, but
VEZA,
the point is
Project
taken,
VEZA.
Chair.
Project VEZA, yeah.
Chair, so the evidence that will be placed before you will begin with the evidence of Dr. Mufamadi. Dr. Mufamadi was appointed by the president, the sitting president in 2018, to chair a high-level review panel. And he produced a report. They finished their work in 2018. You'll hear about the panel and its expertise and its work. They produced a report in 2018, a redacted version of the report. One of the concerns that Dr. Mufamadi will raise is that people seem to have been asleep when the report was released. The reaction that should have emanated from the release of that report just wasn't there, and that's a matter that Dr. Mufamadi will testify to. The release of the report was conditional. It was released in a redacted form. In other words, certain sensitive areas of investigation and their outcome was redacted from the report. In cooperation with the Director General, Office of the SSA, and the President's Office, the Commission was given access to the full report and was able to consider that full report. However, that full report is classified or was classified. Then there was a process of interaction between the Commission and the State Security Agency and the President's Office. Of course, this Commission is duty-bound to protect what legitimately, and I stress the word legitimately, should be protected, names of operatives and legitimate intelligence methods. Those are entitled to take place to a degree of legitimate, or under a veil of legitimate secrecy. But what is not, for example, criminality, cannot ever be covered legitimately through any classification process, and the secret regulations say so. Chair, but we have now a further version of the report which contains far more, or a greater degree of information than the redacted version released to the public originally contained. So the President and the SSA itself have cooperated in an endeavour principally conducted by the Director General of the SSA, who has the powers to declassify, to produce a further version of the report which is in the bundle. The Project Vesa investigation will be dealt with in detail and evidence this week, and the fruits of that investigation. For that purpose, the Director General has given permission for persons who otherwise would be precluded by law from speaking to communicate with the Commission and to give evidence. So much of the evidence, in fact, all of the evidence that is given this week, Chair, and this perhaps should be a matter of interest to legal representatives here, is either evidence already in the public domain. Much of the evidence, in fact, is already in the redacted version released by the President in 2018, let alone the expanded version now available to the Commission for public release. Or it is evidence which the Director General himself, on consideration, has determined may be released in the hearings of this Commission. So anything of a sensitive nature has the stamp of approval. We've been very careful to clear that. Importantly, Chair, there has not always been agreement. And to the extent that there's disagreement, that matter may be canvassed in evidence or determined by yourself if it comes to that. But for the moment, we have cooperated to release most of the information, not all. And the differences in approach between the legal team and the SSA will become apparent in due course. So, Chair, there are two reasons why the evidence that will be given this week must be given. The first is that it's within our terms of reference. That is not a difficult issue to determine. We have statutory terms of reference as directed under the Constitution by the President. And quite simply, we must do our work. The law enjoins us to give that evidence in public. People can respond, answer, and implicated persons can put up contrary versions or cross-examine if necessary. But the fairness aspect is dealt with. The second is that the restoration of a proper intelligence service also demands the attention of this Commission. You're obliged by your mandate to deal with it. Importantly, Chair, as we know from Constitutional Court decisions, and we know from the act under which we operate, the public have a right to know. And that right to know must be respected. If there has been a threat to the institutions of our democracy through the operations, covert and unlawful operations of the SSA, the public have a right to know. That it is sensitive, there are certain restrictions that we will respect, but unlawful activity must be dealt with. And so we will really address this week, and in submissions before you in due course, Chair, or in evidence analysis before you in due course, answer the question, as I stated earlier, were the capacity and resources of the state afforded to the SSA unlawfully appropriated under a veil of secrecy and unaccountability for personal, political and factional political gain. Sure. That's really what the evidence will deal with.
Okay, thank you, Mr. Pretorius. We are at 11. I take it that from your side you are ready to start leading.
Yes, Chair, we're ready to begin.
There are some housekeeping matters that need to be attended to before you start with Dr. Mufamadi. I think it would be convenient that we take the tea adjournment now, so that when you start, then we can carry on until lunchtime. So let's take the tea adjournment. I hope that the preliminary or housekeeping issues to be dealt with can be finalized by 15:15, but if they are not finalized, there might be a delay before we resume. We adjourn. I have been ready from 1:15. I understand that you needed more time. Are you ready now?
Thank you, Chair.
Are you ready now?
Yes, we're ready, Chair.
Okay, all right. Please administer the oath or affirmation.
Oath.
Please state your full names for the record.
Olisani Sydney Mufamadi.
Hang on one second. If you are going to remove the mask later on, you may as well remove it now. Yeah, okay, all right, thank you. Okay, all right.
Chair, I'm sorry to
Yes.
doing this with your permission.
Yeah.
If we may. You directed us before the adjournment that we have a housekeeping discussion before we proceed with this witness. May I bring to your attention that we indeed engaged a learned colleague of ours from the lead team. The evidence that is going to be led partly will also implicate my client, and there were notices that were provided to us, about 3 pages of it. And we have heard from the evidence leader, Pretorius, suggesting that there is at least 3 reports.
There's
3 reports, Chair. And particularly there is a final version that has recently been discovered, which will be used as this witness lead evidence. We have not been provided with these documents. And part of us placing ourselves on record on last week, and when we were briefed, we have been in engagement with the Commission. However, we have not been responded to today, at least to an extent of being provided all the necessary documents. It might be so, Chair, that my colleague, Mr. Mufamadi, had pointed preliminary issues, which I think, Chair, we need your guidance and directive, because to me it's not clear. Maybe it's just my lack of understanding. Chair, there's the...
Okay, I think let's do the oath first, and then after you can continue.
Thank you, sir.
Yeah, okay.
Please state your full names for the record.
My name is Olisani Sydney Mufamadi.
Do you have any objections to taking the prescribed oath?
I have no objection.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that all the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. Let me check whether the transcribers could hear the registrar. You could not hear her. Yeah, no, I think you must take off your mask so that they can hear you. I'm sorry, Dr. Mufamadi, the oath has to be repeated. They did not hear her.
Please state your full names for the record.
Olisani Sydney Mufamadi.
Do you have any objections to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
I do.
Do you swear that all the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Okay, thank you. You may be seated, Dr. Mufamadi. Thank you very much, Dr. Mufamadi, for coming to assist the Commission and to give evidence. Thank you. Mr. Pretorius, you may proceed.
Thank you. If I may just say, Chair, the document that has been requested.
Oh, I'm sorry. The council had something that he had started dealing with, and I said I would give him a chance to deal with it after the oath. You want to confer with him? Yeah, yeah. Okay. It looks like the matter is settled. Yeah, okay, all right.
Chair, just for transparency's sake, the 3-3 notice that is issued in terms of the rule to persons who are implicated or may be implicated contains full detail of the implicating evidence. supporting documentation or documentation which may be considered relevant to evidence to be given in rebuttal or used in cross-examination should such an application be granted is normally dealt with between the parties. We've issued well over 100 3-3 notices. We're dealing with volumes of correspondence over the weekend. And the truth of the matter is, once the document is tabled, it becomes public domain and will be made available to my learned friend. And it's going to be tabled now.
Okay, all right.
Mr. Mufamadi, would you go please to Exhibit YY2?
Well, Mr. Pretorius, you confirm that we'll be using mainly, if not exclusively, SSA Bundle 02
Yes, Chair.
for the duration of Mr. Mufamadi's evidence.
For Dr. Mufamadi's evidence, we will be using SSA Bundle 02.
Yeah, okay.
Which contains the statements of a number of witnesses.
Yes.
But for the moment, we would just like to place on record Exhibit YY2, which is the statement of Dr. Mufamadi together with the high-level review panel report in its declassified version before you.
Yeah, okay.
Dr. Mufamadi, do you have Exhibit YY2 before you?
Yes, I do.
That is your affidavit and an annexure. But if we could go please to page 32, and we're dealing with the black numbers in the top left-hand corner.
Page 32, you say?
Yes, please.
Okay. Okay.
Is that your signature there?
The one just above the word deponent. Because there are two
So if you
signatures
look at the top left-hand corner, Dr. Mufamadi, of that page, of any page.
Yes, that's my
You have it.
signature, yes. So you are using the black numbers?
The black numbers.
Fine.
Yeah, you can disregard the red numbers on the pages.
Okay.
Yeah.
So happily ignore the red numbers there for administrative purposes only.
Okay.
And the statement that you have made for the purposes of your evidence begins at page 3 of SSA2. Do you see that?
Yes.
That is your statement.
This is my statement.
Are you satisfied that the contents of that statement are true and correct?
I am satisfied, sir.
Thank you. What is your current position, Dr. Mufamadi?
Mr. Pretorius, sorry, do you ask me to admit this, his affidavit as an exhibit?
Yes, please. Chair, if you would admit it as Exhibit YY2, the affidavit, and the document annexed, which we will deal with in evidence, to a degree.
The affidavit of Folisani Sitnim Mufamadi, which starts at page 3, is together with the annexures to it admitted as Exhibit YY2.
Thank you, Chair. Your current position, Dr. Mufamadi?
I am currently employed by the University of Johannesburg as director of the school, well, it's now called the Center for Public Policy and African Studies.
Right. The content of your evidence today Dr. Mufamadi will deal with state security and the events over a period of review that we will come to in a moment. Your background in this field, would you briefly place that before the chair?
Yes, I've been in public life for over 45 years now. Just to give you the relevant highlights relevant to what we are about to discuss, during the transition from the apartheid dispensation to the new dispensation, I became one of the cohort of activists who were charged with the responsibility of managing that transition. Those were difficult times when one of the single biggest threats facing the transition was the politically orchestrated violence. And needless to say, ending that violence was an important element of the equation of change. So I was one of the people who conceptualized what came to be known as the National Peace Accord, involving all the politically interested parties in the country. And therefore, I even served on the National Peace Committee, which was a multi-party formation, which sought to level the political playing field in the country at the time. At some point in that transition, a transitional executive council was formed, which really was a manifestation of a situation of dual power in the country, because the elected bodies lacked the necessary legitimacy to see that transition through. So the Transitional Executive Council was formed, and I served on one of its sub-councils. And that sub-council was called the Sub-Council on Law and Order. And again, our responsibility was to ensure that there is effective governance of the conduct of people in the security establishment during that interregnum. This was really a period which required a lot of rethinking, reimagining, because you couldn't do things in the same old way if you were to have a thoroughgoing process of transition in the country. So one of the things we did in the Sub-Council on Law and Order was to conceptualize the normative framework for the practice of statecraft in the functional area of security, broadly defined to include even civilian intelligence. So from that point of view, I have been, I will say, a policy practitioner even before the new dispensation was instituted. I then participated also in the process of formulating the program of demilitarizing policing culture in the country. I think the chairperson will recall the period during which a piece of legislation had to be acted. It did not emanate from Parliament. Some people used to call it colloquially the Goldstone Act, which talked to the issue of public order policing. I was party to the process of conceptualizing that whole framework and the legislation itself. So, for sure, from the point of view of practice, I can lay some modest claim to having acquired some knowledge which I think the President recognized when he asked me to participate in this high-level review panel on SSA. Thank you.
Thank you, Dr. Mufamadi. If you would then tell the Chair, and you deal with that in paragraph 2.1 of your statement, of the high-level review panel and your appointment, and what its key objective was in 2018. You deal with that in paragraph 2.1.
Yes. Well, really the objective, as the name implies, review panel, it was to be involved in a process of looking at the rear view mirror, what happened in the period under review, the role that was played by SSA, and actually to look at, okay, these are the functions of the civilian intelligence agency in the system of government. Does the agency have the requisite capacity, skilled personnel to execute the task it has? That was one. The other then was to look at, you do have oversight mechanisms since we are a constitutional democracy, which must be relied upon to ensure that organs of state act in accordance with the dictates of the law.
Breach of the Constitution, or may have been oversight, or whether it was deliberate. You might not be able to say, but I make an example about the commission. If Dr. Mufamadi has been watching the proceedings of the commission for a long time and knows from that witnesses come in and sit there and give evidence from there, and when he's supposed to come and give evidence, he comes and sits here, you would say, but he knows where the witnesses sit, what happened. You know, it can't be because he didn't know. So I wonder whether the panel dealt with that, but if the panel didn't deal with that, whether having regard to what you was available or was known, you might be able to say something. If you are not able to say anything about it, that's fine, but you can deal with it later on if that's convenient.
Chair, well, as I say, the manner in which the matters that are contained in the proclamation were introduced was manifestly unconstitutional. Now, in general, we ought to know what it is that the Constitution sought to avoid. So, if between the time, or let me say after the proclamation was introduced, the things that the Constitution sought to avoid, including what we are referring to as doctrinal shift, it's not just theoretical postulates. It has some materiality. So after the proclamation has been introduced, you see things happening at least for a period of 4 years, because the relevant legislation, so to speak, which grounded the, let me call it the new dispensation. If it took 4 years after the proclamation was issued for the law to come into place, and so many things happened which were untoward from the evidence given to us, it becomes difficult to believe that the wrong things were not of proclamation provenance. Yes.
In other words, are you saying it becomes difficult to say, to the extent that the proclamation went against the Constitution, this was because of oversight on the part of those who did it? Government functionaries and ministers make decisions that are later found by the courts to be unconstitutional all the time. Sometimes they're constitutional, sometimes they're not constitutional. It doesn't always mean they deliberately decided to do something unconstitutional. It doesn't necessarily mean they deliberately went against the Constitution, knowing what the Constitution says. But there could well be a situation where, for whatever reason, somebody decides, well, this is what we'll do. Obviously, if it's oversight, one looks at it in a certain way. But if it's like deliberately a decision was taken, we will do this even though we know it's against the Constitution, then one looks at it in a much more serious light. So what you are saying, does it go anywhere towards any of this, or it's difficult? As I said, if you can't say, you feel free to say,
yeah,
I
Chair,
can't say.
Chair, what I'm saying is, it is difficult for anybody to say if the act of introducing the proclamation is an enabler for wrongdoing. And then in this instance, wrongdoing ensued after the introduction of the proclamation.
Yes.
It will be difficult for anybody to argue
Yes.
that there is no causal link
Yes.
between the two.
Okay.
Okay.
Thank you.
Yes, of course, there is the added consideration, Dr. Mufamadi, which you may, in response to the chair, also perhaps deal with, and that is to answer the question why Parliament, with its several hundred representatives, sat by and watched what appears to be, at face value, a usurpation of its powers on a non-constitutional basis.
Yeah. Yeah, maybe I'll preface my answer to this question by saying that I find it astounding, and I'm speaking on my personal behalf and on behalf of the panel, that we are not appearing to be ready to part company with the obsession with secrecy, undue secrecy. Because if you could have an unconstitutionality to persist for that long, usurpation of parliamentary power, and we pay the price that I think we paid as a nation. Why was Parliament sleepwalking? If we are not safe in the hands of a body as important as that, I'm sorry to bring in even the judiciary, because I mean, I believe that being proactive does help sometimes. So the whole nation went to sleep for that long period. The moment this matter is raised in as sharp a manner as it was raised following the release of this report by the president, one expected to hear a lot of public discourse around it, because our democracy and our own lives depends on our own vigilance. So it is a matter that gives me sleepless nights up to now.
Well, I won't defend the judiciary when they don't deserve to be defended, but I think in this case I must defend them. Remember that the judiciary can't give a directive, say, bring that case here to us. Somebody must bring the case, you know, even if they read in the newspaper about some unconstitutionality, unlawfulness that whether it's parliament or the president is doing, they are not supposed to say, bring that case. Somebody must bring the case. And once they have brought the case, then it's the duty of the judiciary to do its job. So, so unless, of course, you have knowledge that it was brought and the judiciary didn't do its job.
No, I think this is part, Chair, this is part of the discourse we should have in the public domain.
Yes.
Yes, because I think the lessons that come from this experience are so profound that we may have to rethink quite a lot of things.
No. That's fine. It's quite important. Nobody says we shouldn't include in the debate things that we might not have for some time thought should be done. We are faced with serious challenges that may require things to be done differently from how they've been done before.
Yes.
You know, but I think part of what you are saying is you are astounded by the fact that the relevant parliamentary committee and parliament seemed to do nothing for about 4 years when there was this situation which, as far as you are concerned, was quite a clear unconstitutionality. Yeah, okay. Mr. Pretorius.
Yes, thank you. You go on in paragraph 1.5 to place the findings of the high-level review panel in the context of the work of this commission. And you ask the question whether the capture and repurposing of the SSA, as indicated in your report, was designed to and did facilitate and protect the project of state capture or alleged state capture. That is the question which we will deal with in your evidence. I may rephrase it so as not to include terminology that might foreshadow the findings of the chair, to say that what your statement will deal with is the question whether there was an appropriation of state institution and its resources under the veil of secrecy for private and political gain. Would that be a fair summary of the question you put there?
Sure, and I think this we can explain why we were puzzled. We can explain it on the basis of some evidence that was put before us.
If we could go back then to the high-level review panel, its formation and its activities. In paragraph 2.3, you say to the Commission, to the Chair, how the panel went about its work. Could you just tell us something of that, please?
Well, what the panel did was that we requested documents from the SSA, which we thought were going to assist the panel to better understand its own task. So an extensive number of documents, including policies, legislation, regulations, and directives, previous review reports, because there had been review reports before, and discussion documents, as well as investigative reports. We asked for those documents to be made available to us. We invited submissions from various units of the State Security Agency and from other sectors of the intelligence community. That would include crime intelligence in the South African Police Service, defense intelligence, financial intelligence center, we invited the Inspector General for reasons which should be obvious, given that we needed to understand the efficacy of the oversight mechanisms that are in place. We interacted with the Auditor General. We invited practitioners, past and current, individuals from members of the community. Not only the ones who are operating at national level, but as well as those who are operating at provincial levels and so on. So that's how far we went. We interacted with the relevant committee of parliament. Yes.
The panel also interviewed a number of senior executive members and senior administrative personnel. And those interviews were recorded, correct?
Yes.
The documentation and the recordings, in fact, all the record of the panel are lodged or have been lodged with the SSA and are under the control of the SSA.
Yes, they are under the control of the SSA.
And we've been given access to those, particularly, Chair, and this will become relevant later, transcripts or recordings, rather, of certain implicated parties. Unfortunately, at least one of the transcripts has been totally corrupted and we can't hear a word. One can make of that what one will, but that will in due course be placed. Relevant portions will be in due course be placed. But that process of going through the transcript is not, with the recordings, is not yet complete. If we could turn, please, because I would like to introduce the documenter next, to your to the exhibit at page 32.1. That's the annexure to your statement at black number, top left-hand corner, 32.1.
Okay.
You will recognize
You say
this document.
page 32.1.
Yes, black numbers in the top left-hand corner of each page.
Okay.
There.
Yes.
You have it. You recognize that document.
I do,
take
sir.
it that's the high-level review panel report.
Yes.
But it's important to place on record what we see there. You know that you presented, because you say so in due course, the high-level review panel report in its full unredacted version to the President in December 2018, correct?
Yes.
A redacted version was then released to the public by the President's office.
Yes, on our recommendation.
On your recommendation.
Yes.
Certain portions were excluded for security reasons.
Yes.
Since then, and in cooperation with the Commission, a declassified version of the whole report was given to us, subject to certain conditions. That is the unredacted version. Unredacted version, now the complete version, was afforded, or the Commission was given access to it, subject to certain other redactions, but of a lesser import than had been redacted originally. Now, the declassified, and the report was declassified by the Director General.
Yes.
To the knowledge of the President's office. Subject to those conditions, the declassified version of the high-level review panel report, which includes certain redactions, is now available by direction of the Director General. And that is the document that appears at page 32.1 and following. Am I correct?
Yes.
Right. Paragraph 2.4 of your statement or your affidavit, Dr. Mufamadi, you deal with the operations or the investigations of the panel in a little more detail. Would you deal with that, please?
2.4.
2.4.
Let me just look at it.
And 2.5, in fact.
Okay. I'll have to spend a bit of time looking at it.
And in particular, in 2.4, you mention investigation into operations and funds in relation to the operations.
Yes. Yeah, what about that? You want me to say something about
Well, perhaps I could just put it to you because it's not controversial. The panel examined a unit called the Special Operations Unit. It's a Chief Directorate Special Operations.
Yes.
Those are covert operations.
Sure.
And you looked at certain operations conducted by the Chief Directorate Special Operations, and you examined how funds in relation to those operations were spent and how they were accounted for and not accounted for. Am I correct?
Yes.
And the General Manager Special Operations and later the Deputy Director General Counterintelligence was also interviewed by you in relation to those topics. Is that correct?
Yes.
You also engaged with the Joint Standing Committee on Intelligence, the Parliamentary Committee, the Inspector General and the Auditor General, as you've said. Is that correct? Is that correct?
Yes, yes it is.
And you've also mentioned that your terms of reference were limited to the State Security Agency, but nevertheless, you invited submissions from its sister organizations, Crime Intelligence, that's the intelligence division of the South African Police Service, and the intelligence division of the South African National Defence Force. Why did you invite those representations or submissions? You deal with that in paragraph 2.6.
Yes, we invited what you are referring to as sister organizations because of the similar environment in which these intelligence divisions work. And after all, even their work, the work of defense intelligence, crime intelligence, the civilian intelligence community is coordinated through a structure called NICOC. So it's not easy to make the determinations that we were being asked to make if we are just looking at the operations of SSA in isolation from the entirety of the intelligence community. So that is the reason why we looked at these others.
Yes.
But again, the general point really to make is that intelligence statecraft has the possibility to invade for reasons that all of us have been referring to, secret nature of your operations and so on, to invade regular governance. So it was also important for us, coming back to that question, Chair, as to whether there was a deliberate intention to do wrong and so on, also to try and understand whether some of the things that we were seeing, which were untoward, were a peculiarity of SSA, or to what extent does this intelligence work lend itself to these issues of invasion of regular governance. So there was a necessity for us, indeed, we thought,
Yes.
to try and have a broader, a broader base from which to come at this issue.
Has the light improved anything?
Yeah, I think it's a bit more comfortable.
Okay, all right.
Yeah.
Okay.
So I'll try also, my hand just remained where it was. It was unintentional. Yeah.
No, that's all right.
Dr. Mufamadi, you say in paragraph 2.6 that you actually made, or the committee made, a recommendation in relation to the activities of crime intelligence and defense force intelligence. Do you recall that?
Yes, we did.
What was the recommendation?
The recommendation was that the president should consider having a similar process of review directed at these other agencies that are part of the community to which SSA belonged, because we thought that there may well be takeaways from what came out of the review that the panel conducted, which can give some idea as to what needs to happen to the entirety of the intelligence community going forward.
If one then goes on to paragraph 3, you there set out in paragraphs 3.1.1 to 3.1.12 the terms of reference of the panel. The terms of reference, it's apparent, were very wide and covered a range of topics. We don't need to go into them all. There's a matter of record. But I would like to just draw the Chair's attention to the term of reference 3.1.5, the effectiveness of controls to ensure accountability. How did you understand that term of reference?
Yeah, you see, in any organization, besides the service which the organization renders to its clients, in this case, to the people of South Africa, you must have what you call internal environment control. Very important in a situation where you use public resources to do your work. Those resources must be fully accounted for. I think as we go on, you will see why we thought there was a problem with the internal controls.
And if we could also mention 3.1.7, one of your terms of reference was the involvement of members of the National Executive in intelligence operations and measures to prevent this. What was the underlying principle which gave rise to that line of inquiry and term of reference?
Yeah, well, as I said, you see, the Constitution is very clear as to how to limit and constrain executive authority so that a member of the executive does not end up getting involved in operational issues and so on. That would then constitute an executive overreach. You couldn't have a review process of this kind without trying to understand whether such a transgression happened or not. So this term of reference was directing us to look at that issue.
Right. And then in 3.1.9, you refer to a term of reference which asks for the investigation and development of guidelines that will enable members to report.
I'm sorry, Mr. Pretorius. 3.1.8 is quite interesting. It does seem to relate to, is it 3.1.7?
Yes.
Yes.
How did you understand that one? The policy framework, including legislation that governs operational activities conducted by members of the National Executive.
Okay. Yeah, no.
You can see that it is interesting.
We understand, we understood that if you add the word not, you will have understood what your brief was. But it was in a situation where the not was always neglected, was often neglected.
Yeah.
Yes.
Okay.
Yeah.
Okay. All right. Continue, Mr. Pretorius.
Yes, in due course, Chair, we will refer to provisions of the current legislation that deals with the role of the executive in relation to the operations
Yes.
of the SSA, and we will deal with that through Mr. Jafta, the Director General.
Yes.
The provision in 3.1.9, the development of guidelines that enabled members to report a manifestly illegal order, as envisaged in section 1196 of the Constitution. The evidence, perhaps not directly given by you, Dr. Mufamadi, but certainly other evidence, will reveal that manifestly illegal projects were carried out, devised at a higher level and executed by subordinates. We know that the Constitution makes it very clear, and that is born from the history of state security in South Africa over many decades, that illegal orders simply may not be obeyed. The Constitution takes the trouble to say that expressly and in detail. Do you have any comments there as to the term of reference and why that should be there?
Yeah, well, as you correctly said, I think You know, we are all South Africans here. We know what happened in our country before 1994. And we saw people coming before, for instance, forums like the Truth Commission and saying, I was obeying orders. And those orders, all of us would have agreed then that they were manifestly illegal. So you needed something that does not put your operatives at the mercy of people who are wont to do illegal things, but they are sitting in positions of seniority, you know, giving you orders that are illegal. Something that gives the operatives that empowers them to say, no, I'm not going to do this because it is illegal. So maybe this, I'm saying one would understood this term of reference against that background. And indeed, when people came before the panel, some of them were saying, I didn't know that it was illegal because I was expected to deliver on this matter. So we do make recommendations about what we thought needed to be done, that you needed to have something that protects the operatives, and that should be guidelines that are very clear on this issue.
Then finally, in relation to terms of reference, if we could go to the end, 3.1.12, the effectiveness and appropriateness of the existing oversight mechanisms in ensuring accountability and transparency. You've dealt with that to a degree. Is there anything you wish to add?
Yeah. The general point maybe to make here is that on paper, the oversight mechanisms were good on paper, which then makes it difficult to easily understand why some of the things that happened actually happened despite the existence of these oversight mechanisms. And when we interacted with members, and we interacted, members of the agency, and we interacted with even the relevant parliamentary committee, we thought that it will be important. There is a recommendation we make, I'm not quoting the exact words, which was sort of saying that meritocracy in the deployment of people into some of these oversight organs will go a long way towards avoiding a repeat of some of the wrong things that we saw happening. Also, you know, you have got an academy of intelligence. I remember when I was growing up as a youngster, who had primary and higher primary school, and the teachers would sometimes be away from school. They were attending a refresher course. We thought that you know, things like those were a necessity in order to make sure that the necessary capabilities are in place to ensure that these oversight mechanisms do not just exist in name.
Thank you. You then, in paragraph 4, deal with something you've also dealt with, and you're of course free to deal with it in such detail as you think appropriate, but you have touched on an essential aspect of your evidence and of the evidence to follow, that there was a complete mind shift and policy shift and philosophical shift in relation to intelligence operations that took place in 1994, not only in South Africa, but in other countries as well, which distinguished intelligence during the Cold War period and distinguished intelligence under a democratic and constitutional dispensation. Do you have anything to add in that regard? You deal with it in paragraph 4.1.1 and following.
Yes, I think as you correctly point out, the demise of apartheid in this country happened in a world historical moment where we were seeing serious shifts from what defined the Cold War, where many states were fashioned themselves as warrior states, placed intelligence or assigned the intelligence community with the role of identifying enemies of the state. In other words, it was really an anti-people outlook adopted by warfare states then. And the apartheid state was one such state. So when change happened in 1994, there was talk of the need to move away from the mindset of state security to one of human security, so that you sensitize government as a whole to the need for state power to be exercised in the interest of securing your population, what I would call human centricity. But once you say state security, it's a reversion to what we had before 1994, which I think it was a very unfortunate development. So it hit us in the face as a panel. The fact that we were dealing with SSA, which was not called SSA before the proclamation, of course.
Yes, all this is contained in the white paper, which is before the chair and may be referred to in due course as well. There are several principles embodied in the white paper, some of which we've dealt with. But one of these that bears mention because it's relevant to the evidence that you're going to give, Dr. Mufamadi, is the principle of political neutrality. Do you have anything to say in relation to what you say in 4.1.2 and 4.1.3 of your affidavit?
Well, I can only say that I think as we go on, there is some evidence that will be, we will speak to, which was put before the panel, which suggested that these principles, political neutrality, treating national intelligence as a national asset that is politically non-partisan, there is some evidence that was put to us which flies in the face of these principles.
Right, and then in paragraph 5, you deal with the proclamation issued by the former president, Mr. Zuma, on the 11th of September 2009. You've dealt with that already in your evidence. It's not necessary to go back there as far as we're concerned, but if you have anything to add to what you say in paragraph 5.1 to 5.3, please do so.
Nothing to add really, except to say that these you see the intelligence, civilian intelligence community existed in more than one unit. You had you had NIA, which was for domestic intelligence. You had SAS, SAS, South African Secret Service, and the amalgamation of these as a result of the issuance of the proclamation had the effect of creating a situation where some people sat in positions which were non-existent for too long. That does happen in a situation of transformation and so on, but for too long. But also it was a transformation which was happening after the transformation that happened in 1994 up to that point. We thought that the operational efficiency, generally speaking, was somewhat undermined. And that is why we made a recommendation of de-amalgamating the service. But I think the Director General will explain more in detail what then happened.
We go on then to paragraph 6, where you deal with some findings that were made. It is perhaps important to understand the role of the panel. It was not a commission or a court that made definitive findings of guilt or innocence, as I understand it. But you received a number of submissions and you received evidence which you felt relevant to make findings on in your report. Is that correct?
Yes.
There are two phases of intelligence activity that are relevant to the evidence before the Commission, and those phases constitute firstly the activities of and allegations relating to the principal agent network. I dealt with that briefly in opening. The principal agent network conducted its activities between 2006 and 2011 and was subject to investigation thereafter. Is that in accordance with your recollection?
Yes.
And then the Special Operations Unit.
Yes.
Conducted its activities in a period thereafter. And you had regard to both sets of activity, is that correct?
Yes.
And you summarize the categories, or the nature of the factual evidence that was placed before you in paragraph 6.2.1 to 6.2.3. Would you just deal with those very briefly, please? Just place them before the chair.
Yes. Maybe I must say that there is a bit of a distinction to be made between what we had about the principal agency network and the special operations. We were made to understand that there was an investigation that was underway, looking at what happened in the context of the principal agency network, PEN. The key point that was under investigation, as we were told, was the allegations of abuse of state resources, which then raised the question of the auditability of activities of the agency as well as spend to finance those activities. Now, as the evidence leader is saying, our task was not to take over those investigations, but we thought we needed to record what we were told, because that read together with other evidence that was given to us would form an important backdrop for some of the recommendations relating to, say, financial control, and also how to make sure that you don't have special operations being used as a ruse for hiving off resources from state coffers. That is about now PEN. But with respect to special operations, we found that special operations appeared to be a catch-all phrase for certain things to be done by SSA, which do not fall within the remit of SSA. For instance, protection of political office bearers. I'm just giving that as an example. And other people who do not ordinarily warrant, whose positions do not ordinarily warrant that they be provided with protection at state expense. That is the constitutional function of the SAPS. I'm just giving that as an example. So we found that there had been things like that, and instances of clear weaponization of intelligence capability for ends other than those for which the SSA exists. Partisanship, intra-organizational and inter-organizational. And I think when we move forward, we will talk about some of the operations which are somewhat dubious, that you could only justify if you place them under the rubric of special operations. Yes.
Yes, we've heard many understatements.
Sorry?
We've heard many understatements over the past 3 years, and somewhat dubious is perhaps one of them.
Well, I take it that we are not at a stage yet where we'll elaborate.
Yes.
So I can assure you that by the time we leave here, the commission will know what I meant by that. The commission will know what I meant by that.
Yes.
So, but from what you say, it looks like you are saying that there would have been different categories of operations or units, and it looks like whenever anything couldn't fit into any of the other units or operations, then special operations was where things would be put under.
Yes, but also, as I was saying, those would be projects whose legitimacy
It's dubious.
is dubious, yes. Yes.
Okay.
Yes, and as I said, we will talk about them.
Yeah.
We just need a little bit of patience.
Okay.
But at a high level, Dr. Mufamadi, you say that the investigations of the panel and the information received by the panel covered three broad areas. The first is what you refer to as the weaponization of intelligence services for partisan or factional purposes. The second is the opening up of the resources, particularly financial resources, money, of the SSA to those who wish unlawfully to appropriate that money. And the third is the abuse and bypassing of proper financial and procurement controls. And the projects that we're going to talk about will fall in one or more, or under all of those headings.
Yeah, in one or more. But I think that maybe the point to make up front is that take special operations. To the extent that you had projects that legitimately resorted under SSA, SSA did not need to recruit people other than those who were in the full-time employ of SSA to carry out those tasks. But special ops enabled the employment initially on temporary basis, of people who were outside SSA. And in the course of our interaction with permanent members, you would hear complaints about the ungovernability of these non-members because they considered themselves special because they were involved in special operations. They considered themselves to be accountable to members of the executive rather than to these the management structures of the SSA. And that included them coming forward with requisitions for funding because they are going to carry out these operations and so on. And when they have to account, they say, but we don't account to you. One of the problems we faced as the panel was that at the point at which we were established, the members of that special operations were now aggrieved because they were promised that at some point they will be absorbed into SSA permanently. And the system was refusing to absorb them. I'm just giving that as an example. So you then, in a sense, have a unit which is, I don't want to use notions of rogue unit, but whose legitimacy to exist in the first place is dubious. And then, as we will go into some operations, you will see that those operations, some of them could be justified, but done by permanent members of SSA, and others, it was difficult to justify them.
We'll come to those projects in a moment, Dr. Mufamadi. What you say in paragraph 7 is important by way of background. The notion of a special operations unit that operates covertly, is that unusual in intelligence circles internationally?
Yeah, so
Para 7.2.
Yeah, sure. It's not unusual, but how you constitute it matters. I've already spoken to that issue. Its brief also matters. The fact of it being special does not legitimize illegitimate activities that it may undertake.
Yes.
Yes, and I think that has to be underlined.
Yes. And you say in paragraph 7.3 that much of your work was directed at understanding what happened under the rubric of special operations. Is that correct?
Yes.
Right. And what you're going to tell the chair about in due course is what occurred under the heading or the rubric of state special operations.
Yes.
But just to place it in its context, you say in paragraph 7.1, from accounts provided to the panel, the Special Operations Unit of the SSA was rekindled in about 2011. I take it that that's a reference to the PAN investigation that we know took place in relation to activities of the State Security Agency in an earlier period. What you're speaking about here is what happened in the second period.
Yeah, sure. I think what we are saying there is, to the extent that the notion of special operations by whatever name is not strange to the work of civilian intelligence.
Yes.
It had existed before. Now, you could say that was a reincarnation of what existed before, but it comes with new features that I spoke to earlier.
Right. But what is significant, perhaps, is that what occurred in the earlier period between 2006 and 2011, under the heading Principal Agent Network, was terminated, investigations were conducted, but it seems that the powers that be were unable to or complicit in reviving those types of activities or unlawful activities in the second period from 2011 onwards. Is that correct?
Yeah, well, to the extent that the investigation of PAN was occasioned by the sense that something went wrong, you would have expected that the powers that be would be reticent about a repeat of that. And when you come up with special operations, later you would take care to avoid, as I say, a repeat of that. But what we saw was a repeat of some of what they were investigating in the context of PAN, and more serious, manifestly illegal activities.
I think it's a convenient time to break for lunch, Mr. President.
Thank you, Chair.
We'll take the lunch adjournment. We'll resume at 2. We adjourn.